How to get a high grade in your tort law exam or assignment. First of all, I would like to introduce myself. I am Nini. I'm founder of Simple Studying. We now call our pages Law Simplified because we're changing our name. I have studied LLB and LLM degrees from City University of London. I've got high to 1 and first class grades in my assessment in law school. And then I built this platform to help law students get good grades, just like I did. We're building an AI-powered higher education tool to help students in UK and US universities get good grades. We're expanding beyond law. We started as just for legal education in the UK, but now we are expanding. Why you should trust us. We have 25,000 registered customers already on the platform just for legal education. That's like 25% of total number of law students in the country. 90% of our regular customers have reported to have got a first class. After working with thousands of law students in the UK, we know exactly how to get a first class, as we have a lot of experience in this field. Key topics to revise in tort law: negligence, psychiatric harm, nuisance, and occupiers and employees liability. However, I suggest you have a look at the table of contents of your course, the topics that you have covered on the lecture, and have a look at past exam papers as well to make sure that you are revising all the topics that you should know for the exam. One thing to bear in mind is that if you have like a timed exam where you have a selection, so you are given, let's say, 6 questions and you have to answer 3 of them. You don't have to revise every single topic that was covered on the course. You can do this so-called selective studying. So you can select the topics of revision, just select the topics you like, select the topics that you understand the most and you are most comfortable with writing an answer on an exam, and then just focus on those and you can ignore the rest. Let's say you want to choose 4 topics because you're going to get 3 questions on the exam to answer, and you want to have like 1 as a backup in case you don't get the question that you expected. You could choose these 4, and you could completely ignore pure economic laws, for example, and defamation, which could also be covered on your tort law course. So make sure that you select the topics of revision wisely, because if you don't do this correct, then you won't be able to write your exam properly. So it's very important that you do this right. Use the IRAC structure. IRAC structure is extremely important for law students because this is just the way you write problem questions in law, not just for tort law, for every single topic. First, you have to identify the legal issue. Most of the times I see students just summarize the facts of the case of the problem question and think that's an issue. That's not an issue. Issue is, for example, whether or not duty of care is present in this problem question scenario. That's a legal issue. But rephrasing the facts of the problem question is not a legal issue. After the legal issue, then you have to write the relevant law. So let's say if you have a negligence problem question, you have to explain the duty of care. If you're talking about the legal issue on duty of care, then you have to explain what is duty of care, cite the relevant cases, and then apply it to the facts of the case. You have to say whether or not duty of care exists. And show analysis. There is no right or wrong answer in law. It's not math or physics. There is no right or wrong. It's the most important is that you identify the legal issues in problem question, you apply the relevant law, and you provide analysis. So it's not about saying that, yes, there is duty of care or no, there isn't. It's about making sure that you make all possible arguments. Conclusion, what would be the most likely outcome? So at the end of every single legal issue discussion, you have to have mini conclusions. Negligence. There are 4 elements: duty of care, breach of duty, causation, and remoteness. If you have a negligence problem question, make sure that you discuss all of these 4 elements. In this class, we're going to focus specifically on employers and occupiers liability, which is type of negligence, but it's not the classic negligence scenario where you have to apply Caparo-Robinson test. For duty of care, employers and occupiers liability, instead of Caparo and Robinson test, you have to apply another test. There is different standard of care, but you have to also discuss causation and remoteness like you would for any other problem question on negligence. Employer's liability. It's a common law. It has both common law and statutory aspects. So there is a statute that you may have to apply, but there are also a lot of case law that you need to know about this topic. Employers' personal duty in respect of the physical safety of their employees. All employers have a duty of care towards their employees to make sure that the space where employees work is safe. Vicarious liability is something else. So there is one thing that employers have a duty of care towards their employees, but vicarious liability is when employers are liable for the tort of their employees. So if employee does something that is breach of tort law, the victim, the claimant, can sue the employer instead of the employee. Why would they do that? Because the employee may not have any money. And in tort law, it's not criminal law, they are seeking for monetary compensation. So since employee doesn't have any money, they are going to try to sue the employer instead, who will most likely have more money, or they will have insurance, and then insurance will be liable for payment. Employers' liability to their employees. Consideration takes place of the employer's non-delegable duty of care as ruled in the case of Wilson. So when you cite this principle that employers have a duty of care towards their employees, there is a non-delegable duty of care, you have to cite the cases as well to support those claims. And make sure that you cite the relevant cases for every single principle. An employer does not guarantee that there will be no work accidents. So the duty of care doesn't say that the employer must guarantee 100% safe workspace, because that is impossible. There can always be accidents. But what they have to do is to make sure that it's reasonably safe. An employer itself is at fault because there are unsafe working conditions such as bedly lead stairs. Who is an employee? That's another topic that you need to discuss in the problem question. Don't assume that the party is an employee. Just because they work for the company doesn't mean they are employee. They can be contractors, for example, independent contractors. So you have to discuss whether or not the person you're advising in the problem question is an employee or an independent contractor. And there is a case that you can use to draw the distinction: Ready Mixed Concrete versus Minister of Pensions. There are 2 conditions that has to be met before a worker would be considered to be an employee. So there are 3 categories. There is one employee, worker, and independent contractor. Independent contractor, if it's independent contractor, then employer cannot be sued, because independent contractors are liable for their own torts. Worker is like something in the middle. Doesn't have as many rights as employees, but it's not independent contractor. It's somewhere in the middle. The employee must provide work or skill for the employer in return for payment of a wage or some other remuneration. So this is another condition for someone to be an employee. The employer agrees expressly or impliedly that they will work under the control of the employer, and all other circumstances are consistent with the situation being characterized as a contract of employment. So there is contract of employment, there is control exercised by the employer on the employee, there is a work or skill provided in return in return of a wage or remuneration. And most important here is the control. For example, if someone chooses their own hours, it's more likely they are a contractor. But if someone is given specific job to do within the hours that are set out by the employer and has very little control over their work because it's just doing what the employer is saying, then that's most likely an employee. But someone who has multiple clients, let's say, for example, lawyers can have multiple clients. Is the client employer of the lawyer? Most of the times it's not, because the lawyer has multiple clients, they have control over their time, they're not controlled by their clients. So it's a control test. So you have to look at how much control the employer exercises on the employee. And if like the party has only one, so if there are multiple possible employers, then that indicates more of a contractor scenario rather than employee scenario, because usually employees only have one employer. Safety. It is the employer's duty to ensure that the way in which the employee works is reasonably safe. So not only that they have to provide reasonably safe environment, but they have to implement it as well. They have to implement the relevant measures and ensure that the employees understand the safety measures. And the case for this is Cummings versus Sir William Arrow, 1962. A safe system of work includes giving consideration to the mental health as well. So not just physical safety, but mental health. The case is Walker versus Northumberland County Council, 1995, where claimants suffered a nervous breakdown. At the first time when they suffered nervous breakdown, it was not reasonably foreseeable. So the court said that the employer was not liable. But when the second time it happened, then the employer was liable, because they knew that the employee might have suffered another nervous breakdown if they did not change anything in the employee's workload. They had to just make the employee work less and less stressful work. So the employer was liable for the nervous breakdown of the employee the second time it happened. Bugs versus Low Metals, very important case you should remember. The employer knew that the employee refused to wear safety goggles provided but did nothing. So the employer provided safety goggles, but the employee chooses not to use it. But the employer is still liable, because not only is there a duty to provide a safe system of work, so the employer must have not only provided the goggles, but also made sure that the employees wore the goggles. Cook versus Square Ltd, 1992. The Court of Appeal identified the factors that an employer must consider when determining whether a workplace is safe for an employee. The location, whether the work is required to be done, the nature of the building, the nature of the work required for the employee's expertise and experience, the degree of control that is reasonable to expect the employer to exercise, whether the employee is aware that the premises are dangerous. So you have to discuss every single of these factors when you talk about safety in a problem question about employee's liability, because you cannot straight away assume that the employer is liable. You have to provide critical analysis. By providing critical analysis, you have to make arguments, all kinds of arguments there can be. So discuss the relevant cases, say, did the employee have the relevant expertise and experience to know how to work safely? What did the employer do? Did they provide the safety equipment? Was the employee aware of the dangers? Did the employer do anything to avoid the accident? All these things must be discussed by reference to the relevant case law. Vicarious liability. The general rule is that a person who commits a tort will be personally liable. The claimant brings an action against the person who has caused the harm, damage, or otherwise fulfilled the requirements of the actionable tort. So this is for the torts committed by the employees, and employers can be sued for it because, as I said before, the employees may most likely won't have money to pay. And when someone sues in tort law, they want monetary compensation. So they want to sue someone who has money. And it will be employer, not just because the company has more money than the employee, but also because companies have, it's actually mandatory to have insurance for employers' liability insurance. So if the company gets sued, even if they don't have money to pay, there will be insurance who will be liable for payment. However, vicarious liability provides the claimant the ability to hold someone other than the person who commits the tort liable. Vicarious liability is an important revision topic due to the unique way it imposes secondary liability on someone not directly involved in the tort. So it's a very important area of law that you should revise. A bonus point that is usually not mentioned on lectures, but if you mention it, it can be a very good way of winning some extra points. Usually torts are biased in vicarious liability cases. They usually want the company to be liable because there is insurance in place. So they know that the claimant will get compensation for sure because there is insurance in place. This is usually not taught on lectures, but if you mention it, that the companies have insurance and the courts are usually biased to get to make the company liable for vicarious liability specifically for this the reason of insurance, then you could win some points. Requirements for vicarious liability. First, tortfeasor was defendant's employee, not contractor. This is the case you can cite is Ready Mix Concrete versus Minister of Pensions. Second, tortfeasor committed tort. And third, tortfeasor committed tort in the course of employment. So the first one has to be employee, not contractor, not worker, has to be employee. There has to be some kind of tort committed, negligence, any kind of tort. And third, it has to happen in the course of employment during the working hours when the employee was carrying out their work responsibilities. Acts by the employee that are authorized by the employer are comparatively straightforward. So if the employee was doing something that is directly related to their day-to-day work activities, then that is straightforward. You can assume in a problem question like that this is in the course of employment. But you have to provide analysis. Why was it in the course of employment? What was the employee doing when the tort was committed? And how that activity linked to their employment? Was it during the working hours? Was it outside the working hours? What were they doing? Like the specific act they were doing? Was it like connected to their employment? All of these things must be discussed. For further information, I highly recommend you visit simplestudying.com. We are changing the name of the website to studycrowd.ai, but even if you go to simplestudying.com, you will be automatically redirected. So don't worry about it. Just go to simplestudying.com and find Tort Law there, and you will find all the study notes. I also highly recommend you to get one-to-one tutoring sessions. Our Tort Law study materials are done in a way to make sure that you have everything you need to get a first class. However, most of the students need one-to-one personalized guidance with tutors to understand how to write problem and essay questions. We do give you example problem and essay questions. We give you the kind of questions you're going to get, and we give you example answers so you understand. We give you study notes full of exam tips, but most of the students still require one-to-one tutoring. So I highly recommend you go to simplestudying.com, click tutoring, and have a look at our tutoring packages.